This Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you, Mr. Hivner. Welcome this morning. This is our second day of the May docket of the Tennessee Court of Criminal Appeals in Knoxville. Again, I want to thank Mr. Hivner, our clerk, and his office for their hard work, as well as the hard work of the folks like Jared Walker from the AOC for putting together the technology so that we can hear these arguments in this format. We're all looking forward a great deal to getting back into our court houses and courtrooms, hopefully in the very near future. But over the past year or so, this Zoom technique has provided us with the ability to continue to hear oral arguments on those cases where oral argument is requested. My name is Robert Wiedemeyer. I'm presiding today and my colleagues with me. I'll introduce Judge Camille R. McMullen from Memphis and Judge J. Ross Dyer, also from Memphis. And we'll conduct the proceedings the same way we would in the courtroom. Each side has 20 minutes to argue. I think all of the attorneys here today have been in our court before. We have two defendants in this case, so I'll get to that in a minute. You all have a total of 20 minutes, and I'll hear from you as to how you're going to divide that time. We have read the briefs, so we're prepared to that extent. We have not been assigned the records or gotten into those in any detail, but we're aware of what you folks have put in your briefs, and so you can tailor your arguments accordingly if you wish to do so. Mr. Hivner, any preliminary matters at this point?
No, Your Honor.
Right. If you'll call the next case on the docket, please.
Yes, sir. State of Tennessee versus Rodger Dale Prince and Amanda Beaty.
All right. Good morning. Let's see. I show Mr. Gully is here and Mr. Hedrick, is that correct?
Yes, Your Honor. Good morning. Joshua Hedrick for the appellant Amanda Beaty. If the court please, we had discussed among counsel having myself argue in lieu of both counsel arguing. We're going to present argument on some of the issues and rely upon our briefs on the remainder, if that's satisfactory to the court.
Certainly, and I failed to mention, if you wish to reserve some of your 20 minutes for rebuttal, let me know, and I'll try to let you know when you reach that point.
Yes, Your Honor. So if the court please, I will be presenting the entirety of the argument, and I'd ask that I be permitted 2 minutes time for rebuttal argument, please.
2 minutes?
Yes, Your Honor, 2 minutes, please.
All right, certainly.
If it pleases the court, here on behalf of Ms. Amanda Beaty, my argument will encompass, as I speak, I'll be speaking about Ms. Beaty because she is my client, but our arguments are essentially the same for both Ms. Beaty and for Mr. Prince, at least with respect to the issue that I'll be talking about first, which is that the indictment in this case was fatally flawed. Your Honor, in this case, the indictment failed in its obligation to set out the factual findings that would ensure that a person is tried only on the findings of the grand jury and to ensure unanimity of a jury verdict and protection against double jeopardy. And the reason for that is because this indictment, in its terms, on its face, count 2 charged multiple offenses. Count 2 of this indictment charged felony murder by neglect, but with the language of abuse. And the difficulty is that the statute at issue, unfortunately, contains both of those offenses. And so the citation to the statute itself is of no use. The grand jury in Tennessee speaks, as I don't mean to lecture to the court, but the grand jury speaks through the indictment. And so when we have an indictment with specific factual findings, as we do here, those specific factual findings must be given effect because those are the actual findings of the grand jury. And in this case, the grand jury made a specific factual finding that was then, frankly, undone by the trial court. The grand jurors in this case, in count 2, found that Rodger Prince and Amanda Beaty, I'm paraphrasing because it's a bit long, found that Amanda Beaty and Rodger Prince, on or about June 1st, 2014, did kill Levi Ryan Beaty with the intent to perpetrate or attempt to perpetrate aggravated child neglect by knowingly, other than accidental means, treat the child in a manner as to inflict injury resulting in serious bodily injury. And so that's the difficulty, because this statute, 39-15-401, contains both of those acts, neglect and abuse. And the count appears to contain both of those acts, neglect and abuse, in a way that the grand jury must have specifically found that. It is duplicitous. I've been told that I shouldn't say duplicitous, but should say duplicitous instead. And because of that, it is flawed. We cannot know which of the two is surplusage. The trial court found that there was surplusage in the indictment and struck it. But the difficulty is, in doing so, the trial court necessarily substitutes its judgment for the judgment of the grand jury. Of those two, between abuse and neglect, we have no idea which is the surplusage and which is the true intent of the grand jury. Now, in its brief, the state couches this as a drafting error. And with respect to the government, I think I submit to the court that that is a gross understatement of what we're talking about here. This is not a case of correcting a misspelling or a misplaced comma or some misnumbering, perhaps. If the indictment had 2 count 2s, and the court said, well, this is obviously, we're changing the second one to be count 3. I agree with that. If the indictment misspelled abuse, fine, we'll correct that. Or if it misspelled Ms. Beaty's name, 2 T's, for example, fine, we'll correct that. But this is not a drafting error. This is the inclusion of 2 offenses in a single count that the grand jury says, we find probable cause for both of these offenses. And there's no way to tell if we're right. Because if we are wrong, and we strike as surplusage what the grand jury intended to find, then we have put Ms. Beaty and Mr. Prince to trial on offenses that were not found by the grand jury.
Counsel, let me ask you this. Maybe I am not completely grasping the error here as you're describing it, but if the indictment says felony murder based on neglect and abuse, okay, and you're arguing if the indictment reads that way, the grand jury found both of those, and the trial court strikes the neglect part, aren't we really just in the state really just at that point making an election that all we're going to travel under is the abuse, which the grand jury found? It's not like we're traveling under something the grand jury didn't find. We're just saying that, yeah, they may have found A, but we're only traveling under B. Is that, can that be possible?
So obviously, I think, I don't mean to be informal, Your Honor, but anytime an appellate court asks, can that be possible? I think the answer is always yes. But what I will tell you is that I think that your example is slightly different than what we have here.
Okay.
Because excuse me, you're talking about a situation where an indictment has an and. And I'm not saying that this case isn't necessarily an and, but we don't know if it's an and, right? Because the indictment in this case reads that it was an attempt to perpetrate neglect. But then it says doing it in this way. And so it's unclear from this indictment whether that was an and or a misunderstanding of charge, or because they're in the same statute. Let me come at it from a different way. Because they're in the same statute, we can't know if the grand jury was trying to charge neglect and accidentally used abuse language, or trying to charge abuse and accidentally said neglect. Or the third option, as you stated it, Your Honor, trying to charge them in the conjunctive, trying to charge both. So there are three options there, all of which I submit are equally likely from the language of the indictment. And in selecting one, we necessarily run the risk of rejecting the true finding of the grand jury. And I think that the reason why we're having this discussion is, and I don't mean to cast aspersions on the legislature, but this statute, the way this particular statute is created, opens up this problem for us. Because for the majority of the offenses, you can resolve it by citation to the code section. Charge a theft and cite to the theft statute section number. And if there is a problem, well, we can just look at this is the code section for theft. It must have meant theft, right? It couldn't have meant robbery because they cited the code section for theft. In this case, the code section contains within it more than one offense. And so we can't resolve it in that way, right? So if I turn your example in the other direction and say, imagine an indictment that says, committed the offense of theft in violation of TCA 39 theft section, right? And also assaulted the victim. Then we could clearly say that the assaulted the victim is surplusage because it doesn't fit with the statute that's cited, the code section that's cited. It doesn't fit with anything else. But in this case, the two offenses that are talked about both fit with the statute that is referenced. And that's why we have a real problem here, because we can't say that one is a drafting error and one is not. And that's what I think is the ultimate problem here, is that no matter what we do, we substitute our judgment for the grand jury, and that's what we are not allowed to do. And for that, that's why the appropriate solution in this case would have been to have had the grand jury make the findings again. The grand jury is the only person who can answer this question, and the only way to do that is to dismiss the indictment.
Let me probe a little bit further on this, because when we're talking about an aggravated assault, and the indictment reads either with a deadly weapon or something fashioned so that the individual believes it's a deadly weapon. And the grand jury comes back with an indictment, and we just cite to the aggravated assault statute, or we say in the indictment that, defendant did this by either possessing a deadly weapon or something that was presumed to be a deadly weapon. What we do in that case is you as the defense attorney are going to say, Your Honor, they need to elect. Was this really a gun, and that's what they're traveling under? Or, did he have a baseball bat and made it look like a machine gun, or whatever crazy fact scenario we may have? You're gonna require him to elect, or at least ask the judge to make them elect. Why is this any different?
Because
if it's the same, if I can commit the same crime under two different theories, which is really what you have here, I can commit the same crime under two different theories, can I not? And
I'm sorry.
Go ahead. I mean, if it's a felony murder, can I not commit the same crime under different theories? And if that's the case, why aren't we electing which one we believe as the state that we're traveling under? And you have sufficient notice, because we don't require specific notice anymore. We require general notice in the indictment.
So the difference, Your Honor, is that in your example, there is a single fact pattern with two different legal theories, right? That this is either a deadly weapon or it's fashioned to be like a deadly weapon, but it is the same object, right? Either it is, I threatened you with my pistol, or I shot you with my pistol. It's still the same pistol. It's still the same set of facts. Whereas the difference between neglect and abuse encompasses a separate set of facts with a separate set of defenses. And the defenses to abuse may not be the same as the defenses to neglect. Whereas whether I'm talking about looks like a pistol or is a pistol, as a defense lawyer, my defenses are the same, right? I'm dealing with the same facts and the same arguments. And that's the difficulty that we had in this case, is that this was a case where it made a difference, a big difference in the litigation, who did what and when. I think it's clear from the record that the question of active role versus passive role, exposing to harm versus actually committing the harm, was central to what the jury was asked to decide. And this question of neglect versus abuse is essentially that claim. And so you run the risk of a juror number 4 may think that I think that she committed felony murder because she neglected the child. And juror number 5 thinks I think she committed felony murder because she abused the child. As written, the indictment would allow those jurors to have a unanimous verdict, but I submit to the court, I hope I'm right, that that isn't a unanimous verdict because they found different things. They found different acts. And there's no way to know that. There's no way for defense counsel to adequately divide those questions for the jury. And I think that's borne out by the verdict in this case. Obviously, the jury makes the decisions that the jury, we don't know what was going through the minds of the jurors, but we have a case where the jurors, in the face of scientific proof that Ms. Beaty was not present and could not put together enough force to cause this death, and yet is convicted in count 1. And we address that in the sufficiency argument that I'd like to think is set up adequately in our briefs. But that's the core of that question. The second error we suggest to the court is that it was error for the court not to grant a mistrial after the second instance of expert witnesses volunteering to the jury inappropriate testimony. And I highlight that they're expert witnesses because I think that makes a difference. And I want to be careful in how I present this. I don't mean to cast aspersions on expert witnesses. So when I say professional witnesses, I don't say that in a way that casts aspersions, but I say that in a way that highlights that these are people who are different from your average layperson who has never been in a courtroom before and is unfamiliar with rules of evidence. These are people who, Dr. Malusnik, we see in the record in volume 25 at page 475, she testifies that she has 20 years experience testifying and that she's done so many trials, she's lost count. 20 years is a long time to be experienced in testifying in court. And it is too long to still be making these sort of accidents. And I'd suggest to the court that the first witness, Dr. Palmer, who says that she was impressed by how happy the baby looked as opposed to the way he looked before, that isn't scientific and it isn't appropriate and it is an appeal to sympathy and it should not have been permitted. And there are in trial work, as each and every one of your honors knows, in trial work, the plan survives only until they swear the jury, and then it all goes its own way. However, it happened again. And it is our position that when it happens again, that's when you start to have a difficulty, a second appeal to sympathy. Unresponsive to the question. The question is, this would take a lot of force. And the answer is yes. He was tortured until finally the aorta snapped. That's not the answer to that question. That is a volunteered statement. And the word torture, I submit to the court, is not a medical diagnosis and is not a scientific proposition, but merely an appeal to sympathy and an intentional appeal to sympathy from a witness with 2 decades of experience testifying. Should know.
Would it be okay if that witness had testified he was shaken, he was beaten, some verbiage like that until the aorta? Your complaint is the word torture.
Yes, Your Honor, because it's such a loaded word, because it isn't a scientific word. It is a word intended to evoke a response. And that's why it's different from beaten, shaken, struck. All of these things are scientific in nature. Impact, a force, a shooting, a stabbing, any of those are scientific words. Even a great deal of force or an extraordinary force could be a scientific word. But torture is not a diagnosis. It is not a scientific word. It may be, you may find a scenario where someone says that a certain act is torture from a the standpoint of describing it in common parlance, but it is not an accident. And what gives further pause is that the state's reasoning is that in the record, the state argues that this happened because defense counsel pushed her around. And that's in the record, volume 25 at 531. And that I submit to the court is important, because the state's position isn't she made a mistake, she slipped, she thought it was appropriate, she shouldn't have said it, we all make mistakes, I'm sorry, we should have told her don't say torture. The state says it happened because defense counsel pushed her around. And that suggests that it wasn't accidental, because nobody says it's accidental. That's their opportunity to tell the judge this is an accident, well, we'll do better in the future. And they don't. And it prejudices the judicial process. It precludes an impartial verdict, especially in a case that's already emotionally charged. We have a case that's being tried out of its home county because of a motion to change venue, dealing with the death of a very young boy who will submit to the court was an adorable little child in the photographs. This case began with a high level of emotion. And this was gasoline on the flames. And for that reason, it rises to the level that something should be done. If there are no other questions about the issues I've discussed, I'm happy to discuss them, but I believe that will conclude my argument, Your Honors.
All right, thank you, Mr. Hedrick. You still have your rebuttal time also, if you wish to use that.
Yes, Your Honor.
All right, good morning, General Redding. Are you ready to argue?
I am, Your Honor.
All right.
May it please the court, Catherine Redding on behalf of the state. The trial court acted within its discretion when it granted the state's motion to amend the indictment. I think it's helpful to understand exactly what the superseding indictment said and what the amendment to the indictment did. The superseding indictment in count 1 charged the defendants with felony murder based on aggravated child abuse, and it set forth the elements of aggravated child abuse. Count 2 of the superseding indictment charged them with felony murder by aggravated child neglect, but then went on to set forth the elements of aggravated child abuse rather than neglect. When the state filed its motion to amend the indictment, it proposed only a change to count 2 of the indictment. It left the felony murder by aggravated child neglect part alone and just changed the specifics of the elements of aggravated child abuse so that they accurately reflected child neglect. The defendants claim that they're entitled to relief because the superseding indictment was duplicitous, but that is not the critical issue before this court. The issue is whether the trial court acted within its discretion when it allowed the state to amend the indictment to remove that language about aggravated child abuse from the count that clearly charged the defendants with felony murder based on aggravated child neglect. Rule 7B2 of the Tennessee Rules of Criminal Procedure is the controlling law here. That rule says that a trial court can amend an indictment without the defendant's consent before jeopardy attaches if there's no additional or different offense charged and if there's no substantial right of the defendant that is prejudiced. And both of those elements are met. The amendment did not change or did not charge an additional or different offense than the superseding indictment. Count 2 of the superseding indictment clearly charged the defendants with felony murder. It tracked the felony murder statute. It referred to the felony murder statute. It never actually referred to any the underlying felony statute. So it referred to the felony murder statute. It stated the underlying felony of aggravated child neglect. It provided the date of the offense, and it identified the victim by name. Felony murder indictments have to allege that a killing was committed during the perpetration of a felony, but these types of indictments are not required to allege the elements or the facts of the underlying felony. And in that case, it would have been the underlying felony of aggravated child neglect. So when the amendment changed the elements of the underlying felony, it did not change the charged offense. It was felony murder by aggravated child neglect in the superseding indictment. It was felony murder by aggravated child neglect in the amended version of the indictment. The charge never changed. And as to the second element of Rule 7b(2), no substantial right of the defendants was prejudiced. The aggravated child abuse language in the superseding indictment was surplusage. The defendants clearly understood the difference between the two felony murder charges before the state filed its motion. I've talked about this in my brief, but it's worth noting that at the motion on this, the state's motion to amend the indictment, defendant Beaty admitted at the hearing that she wasn't surprised by the motion the state had filed, by the change the state had proposed, and even said that it would be a bit disingenuous to claim that it was surprised. And although defendant Prince didn't offer his own argument at the hearing on this motion to amend the indictment, he did say he adopted defendant Beaty's objection to the amendment, and he specifically said that he adopted her argument. And by doing so, he adopted he also embraced her acknowledgement that this was not a surprise. And this lack of surprise is likely why the defendants, faced with an amendment to the indictment, never requested a continuance to try to claiming that, oh, well, we need more time. We weren't expecting this. We need more time to prepare for trial. I mean, it is clear that a superseding indictment clearly charged felony murder by aggravated child neglect, that the amendment to the indictment did not change that, and that the trial court acted within its discretion when it granted the state's motion to amend the indictment, and the defendants are not entitled to relief on this particular claim. If the court has no questions on that, I'll move on to the mistrial argument. The trial court also acted within its discretion when it refused to declare a mistrial. As to the first claim regarding Dr. Palmer's testimony, the record supports the trial court's decision here. The state did not elicit this testimony. What the record shows is that the state was showing Dr. Palmer a series of photographs of the victim that she took at the hospital, and that Dr. Palmer had been engaging in an explanation of why she took each photo. Essentially, she was referencing the injuries that were depicted in the photograph. The state asked Dr. Palmer, showed Dr. Palmer a photograph of the victim's face, asked Dr. Palmer why she had taken the photo, and that photograph was designed, if you look at the record as a whole, it was designed to elicit testimony from Dr. Palmer as to injuries, specifically injuries on the victim's face. It was not to elicit a comment from Dr. Palmer that she thought the victim looked happy. And I just note for the record that Dr. Palmer never actually finished her statement. She started to say, well, I took this photograph because the victim looked happier than, and then there was immediately an objection. So we don't really know what Dr. Palmer meant when she said that. But regardless, it was not, I think the pattern of questioning from the state and the full record shows that the state was not trying to get this information in. It really thought that Dr. Palmer was just going to continue in the same vein that she had been in offering testimony about what the photograph showed about the victim's various injuries. The second portion of this is that the trial court gave a curative instruction and told the jury to disregard the statement made by Dr. Palmer, and jurors are presumed to follow the directive of the trial court, and there's nothing in the record to indicate that there is a reason to deviate from this presumption. And third, the state's proof was relatively strong, given defendant Beaty's failure to believe that the victim was being abused and to act accordingly, a willing failure to believe that. Her creation of an environment where the victim sustained ever worsening injuries, her failure to supervise the victim when he was with defendant Prince, proof showing that Prince was the only adult home when the victim sustained his fatal injuries, and the defendant's repeated lies about the victim's final moments and their attempts to mislead law enforcement about their roles in his death. And for those reasons, Defendant Beaty is the only one who's objected to Dr. Palmer's testimony on appeal, has failed to establish manifest necessity for a mistrial based on Dr. Palmer's testimony. But the record also supports the trial court's refusal to declare a mistrial based on the medical examiner's testimony. The state did not elicit this testimony. Defendant Beaty did elicit this on cross-examination. The trial court gave a curative instruction, told the jury to disregard this testimony, act like it had never heard it, and the jurors are presumed to follow the trial court's instructions. There's no reason to deviate from that presumption in this case. And as I stated, the state's proof was relatively strong. And I'll note that the medical examiner had already detailed horrific abuse of this victim before she used the word torture. I mean, the jury at this point knew that the defendant died after all of the blood in his body was drained as a result of these traumatic injuries, heard that his spine was intentionally snapped in half immediately before his death, that his aorta was torn, and that's what caused his heart to pump out all of the blood in his body very quickly in his chest cavity, and that he had bruises on his face and neck, that he had chipped teeth, and that he had a deep laceration in his upper lip. And they had already heard the medical examiner say that, or the medical examiner's reading of this was that somebody may have grabbed the victim by his neck and ankles and twisted his body and snapped his spine. So given the evidence that was in the record about the victim's injuries, the state's relatively strong proof, the one-time use of the term torture was not sufficient, or it didn't establish manifest necessity for a mistrial, given all the factors that this court must consider when determining whether a mistrial was necessary based on inappropriate testimony. And I'll note that this court reached a similar conclusion under similar facts in that the testimony was elicited on cross-examination by the defendant rather than the state in State v. Luna, which I've cited in my brief. This court found there was no abuse of discretion to deny a mistrial, where the testimony resulted from questions asked by defense counsel, that the state's proof was relatively strong, and that there was a curative instruction that was given promptly by the trial court. If there are no questions, the state asks the court to affirm the judgment of the Morgan County Criminal Court.
Thank you, General Redding. Mr. Hedrick, rebuttal argument?
If it please the court, I digitally rise only to point out that the harm here is the right to be tried only upon the findings of the grand jury. And that is a significant harm in and of itself that must be countenanced. Thank you, Your Honors.
All right. I just have a question, just
Yes.
kind of curious. This is a Morgan County indictment, but you said there was a change of venue. Where was it tried then? I'm just wondering.
It was tried in Loudoun County, Tennessee.
Okay.
So
Okay.
it was within Judge Wicks's circuit.
Okay.
A different county, so we'd have a different jury from a different county.
Got it. All right. Mr. Gully, we've seen you 2 times now, but we've not heard a word from you, so I'm not going to allow you to talk. Everything's good. No, seriously, appreciate your being here, and all of the attorneys. The briefs in this case have been well written, and the arguments were excellent and very helpful to us. And we'll study the briefs and consider your arguments, and of course, get into the record, and we'll render an opinion in due course. So thank you very much. Mr. Hibner, we'll stand in recess then, please, until the next case.